Thank you, SG. Let me also compliment the point that has been mentioned by my colleague from Zambia. Went through the SADC model law and unpacking in terms of what it was, the gender discrimination component, human rights and legal law, and the consultant informed us that extensive consultations were done. Even in your speech, it was there, and that we are, as we speak as a region, we are speaking for the voiceless. We are speaking for the people that when the people have spoken, it is God who has spoken. We also went through on through the guiding tool, as a guiding tool, and the processes that were involved, and the objectives that GBV is an affluent human rights, that the model law has taken a rights-based approach in terms of protecting the rights of those that will be actually the victims of gender-based violence. There was also a notation that there are inadequacies within national laws in our countries vis-a-vis the constitutions in our national countries, and the lack of adequate access to justice provisions. I think it was more pronounced when the researcher was actually presenting that there's a lot that we need to do in our countries vis-a-vis the proposed law, and then the lack of resources in terms of implementation when it comes to programs, when it comes even to protection of those that will be victims of gender-based violence. Then we had to resort back so that we could have a system in terms of presentation, where we were now moving chapter by chapter so that members would make an input in terms of what they would see as missing or to improve upon every paragraph. And in short, that is what I can say that the process yesterday. But otherwise, I think starting is a problem. But when you are in the midst, it's actually a process that you will appreciate. So thank you very much.
Thank you. There's no interpretation. Agnes, is it off? Okay, but they can hear this side. Mozambique can hear. DRC, do you have interpretation? So, okay, it's okay, all right. I don't know what's happened with the technicians. Maybe you are the ones cut off. Okay, no, thank you very much, Honorable. That's a very good day and motivating. Is there no, okay, Seychelles?
Thank you, Madam Chair. Good morning, Madam Chair. Good morning, all honorables and all members. Just sort of a brief of yesterday's session. Well, it was very comprehensive, and we really appreciated the way it moved. But there were some issues in regards to the countries, other countries. We have to think region within the region as a region, because once we sort of SADC embarked on the new reform, the new parliamentary reform, we have to think across the board for the region, not for the individual countries. And we should join forces together to ensure that all countries can move ahead at the same time. And especially when it comes to us parliamentarians, ensuring that we provide a conducive environment, legal environment, for our population, especially the high-lying fruits. We have to reach the unreached as when it comes to the key population, to ensure that all their rights, the rights of our citizens, are being met in relation to gender-based violence. And I hope today, the sessions today, we shall join forces together to speak in one voice as a region. Thank you very much.
Thank you very much for those words of solidarity, Honorable. So, honorable members, I would like for us to proceed with business. I don't know if any members online are indicating to take the floor. May I be guided? Yesterday, we made a mistake and forgot to look online while other members were indicating to take the floor. So today, let's kindly keep an eye on that so that we don't miss them. And just to appreciate yesterday, honorable members, it is the nature of coming together to shape something that we would like to all identify with, and also something that we would like to champion ultimately in this regard. And I must appreciate the robust discussions, because that is why the SADC Parliamentary Forum exists. For that exchange, for that quality of debate, for that materiality in terms of how we discuss issues from an evidence perspective and from experience of our countries. And that is why the beauty of SADC-PF is always underlined, because we believe it is a model of parliamentary democracy. We have members, male, female. We have members from ruling and opposition parties. We have members from all corners of Southern Africa. That on its own should be what brings us together, and the pipe dream towards regional integration begins to be more visible, where we see the light at the end of the tunnel. Maybe then just to say a few things that, let me restate that this is a model law. There's no country at regional level, as we know. And therefore, we must focus on how persuasive the model law would ultimately be. So the persuasive value of the model law should really be based on, if today we have, let me use a neutral thing. If today we have, let's say, apartheid, I'm just using that thing, we cannot come up with a model law that maintains the status quo. The model law should go beyond where we are, so that those who are born after us can be able to have an environment that is much more conducive and accommodative. And this is where we are. So the model laws of the SADC-PF, for the benefit of members who are joining us, recently, they've generally been recognized because they have a persuasive value. These model laws have been recognized because substantively, they are solid, based on evidence, based on research, and based on thorough consultations of people who are dealing with issues from a technical perspective to those who are in the front line doing the work practically. That is why you find that these provisions were put together after such a thorough consultation, bringing the diversity that I just spoke of together. You'll also appreciate that the quality of the provisions are based on human rights standards. They're based on treaties, they're based on conventions that we have already signed to as countries. So at all costs, let us look at not giving an individual position, but let us come from a country position in terms of how far our heads of states have already committed. So we're basically restating what our countries have already committed to, and we're not coming up with anything new in that regard. So formally, the process of adoption rests on you as members of parliament, and organically on the nature of the stakeholders that we have involved. We spoke of jurists, we spoke of survivors who have lived this life of being abused and therefore could not find protection, or they have nowhere to hang their hopes for ever getting out or getting protection where their human rights can be protected. And ultimately, let me just say, the modern law is flexible for adaptation. So it is not going to be imposed on your countries. So as we contribute, let us not think about in Botswana, in Namibia. It has to be flexible enough, taking into account, of course, the legal traditions and systems, the autonomy of countries, the religion, and many other things. So I just want to say that as we move along, let us amend with that in mind and not water down what has already been agreed to by our own countries. I thank you, honorable members. Let us proceed in that spirit. I now hand over to the drafter. There's a hand from Tanzania. Yes.
Good morning, honorable members and all. As just said by SG, I just want to add one thing. While we're discussing, we should not also forget that we're Africans, majority of us. And even if you are not African by color, but you are in Africa. So we have cultures, morals, and not only that, we are human beings, we have our own faith. And we are here, a big group which we did not experience many other things which are being mentioned here. And we are happy, we are alive. We are now making a history, as SG said yesterday. Now we should always focus on what type of history are we going to make? History for better future or history to destroy the future? In the coming 100 years, and 100 is a lot, say 50, most of us, grandchildren will be playing on your graves. What is your addition in their well-being? You as a member of parliament, few selected member, elected and selected members of parliament. We are very few here. A lot of our people would like to be in this room, but they are not. Now, I just request you to clear your conscience and think outside the box. The draft is good. Well, it's good and well taken care of. They've taken time to draft it, but it has been brought to us to go through and accommodate what we think is best for future. Here, we are not looking at the language. We are not looking at who drafted it, but you need your own thinking and brain to come up with what you think is the best. Nevertheless, you are coming from which country, but please check your conscience. Thank you.
We may proceed.
Good morning, honorables. Good morning, members of civil society. Today, we commence part 1, preliminary provisions. Unfortunately, we are behind by 2 sessions, session 2 and session 3 in your programs. So we'll try and catch up as best we can. Otherwise, I'm afraid we will not be able to complete our program by Wednesday. I'll have the draft read as you had requested yesterday. To begin reading will be Mrs. Peggy Lazo. Peggy, can you begin reading from the beginning?
Part 1, preliminary provisions. The preliminary provisions consist of matters generally underlying the understanding of the GBV model law. In this part, insert in accordance with the style and form of a member state, a long title, enactment clause, short title, and other preliminary matters as appropriate in the member state. The drafter should take into account and consider the Constitution, acts of general application, customary law, international legal obligations, especially human rights and freedoms.
Just to mention, honorable members, you are now entering the human rights-based approach to GBV. In this part, we are restating certain human rights which directly impact on GBV. And restating, we are making them simpler, using very simple languages which are not written as in your constitutions, but mean the same thing. Further, we are relating them to issues surrounding GBV. So the restatement is just that, using the human rights base to bring out problems and solutions relating to GBV and giving a policy direction to the restated human rights. We are not changing the human rights when we say restating. We are just transforming it to relate it directly to GBV. I thought I should explain that, honorable members.
One, domestication of model law. Subsection 1. Member states shall undertake a process of legislative reform to give effect to this model law and observe its objectives. Member states shall enact and enforce laws prohibiting all forms of gender-based violence that address and punish all forms of such violence in line with international human rights standards as provided in this model law and international instruments on gender-based violence. Member states may use any of the following to domesticate this model law. A, adopt this model law as a whole by scheduling. B, adapt and adopt this model law as a whole as a single standalone law on gender-based violence. C, adopt selected provisions from this model law in parts of the various national laws on gender-based violence. Or D, adapt and adopt selected provisions from this model law in parts of the national law on gender-based violence. Notwithstanding subsection 1, member states that have already in place national laws that prohibit gender-based violence shall review, assess, and strengthen such laws in conformity with this GBV model law. Section 2, application and scope. Subsection 1. This model law applies to all persons without distinction of any kind, such as race, color, sex, age, language, religion, nationality, political or other opinion, cultural beliefs or practices, property, birth or family status, sexual orientation, gender identity, ethnic or social origin or disabilities, taking into account the special needs and circumstances of women, children, and other vulnerable persons. Subsection 2. This model law shall be construed to apply to the full extent of the definition of gender-based violence and to the offenses established under this model law when the offense is committed A, within the territory of a member state, B, on board a vessel or aircraft that is registered under the laws of a member state at the time the offense was committed, or by a national of a member state whose extradition is refused on the grounds of nationality. Subsection 3. For the avoidance of doubt, this model law applies to non-cohabiting or non-marital relationships, individuals with family relationships to one another, sexual relationships, members of the same household, including ascendants, descendants, persons related by blood or affinity, minors or disabled individuals under guardianship or custody, other persons residing in and employees of that household, spouse or former spouse, and violence against or between heterosexuals, lesbians, bisexuals, homosexuals, transgender persons, same-sex persons, non-binary people, and sex workers. Subsection 4. The rights, benefits, protections, interventions, assistance, and services specified in this law shall also apply and be available for victims who are repatriated from one member state to another member state.
Just stop there. Thank you, Peggy. Can we consider now clause 1, don't say section, clause 1 and 2. Clause 1 and 2, honorable members. Yes, Honorable SG, can you please assist me?
We have Eswatini, we have Seychelles. We all, okay, hold on. Let me organize myself, apologies. Let me just take down the okay. We have Eswatini, we have Seychelles, we have Tanzania, we have Zambia, we have Malawi. Wait, oh, Malawi, yes. Any other sort of members? This is where we stop. Mozambique? Okay, thank you. In that order, Honorable Senator Magagula, kindly take the floor.
Thank you, Madam Chair, and thank you, presenter. Question is on the domestication of the model law. It's critical, otherwise our work here would be an exercise in futility if at the end of the day we would not domesticate the law in our respective jurisdictions. But I was just wondering or wanting to know how this will be done such that it gives us opportunity back home to domesticate it. Because I think the procedures differ from country to country. Maybe it's the same, I don't know. For instance, in our own country, in our own environment, any international instrument that has to be domesticated, ratified at local level has to go through foreign affairs. Is this going to be the same thing or what? Because I don't see us carrying this as parliamentarians into our parliamentary houses. It has to go through that protocol. I'm just seeking clarification on that one. And the second and last one, before that, there was a word here, bullet 11, without delay. Has it been deleted or what? Because if it still stands, I'm sure there is some noise. That's why it's in red there. Because the noise to me, with me, would be without delay. Is not making sense. Maybe in terms of the time frame. But if it's out, then I have no problem.
Honorable members, the version you are seeing on the screen is the latest version. It's a tracked version, as that's what was requested, to make it easier even for the translators to track, to see which changes were actually being made. These changes are accumulation of your representatives, civil society, the judges, the human rights institutions, the police, the prosecutors, and so forth, as mentioned in the Honorable SG's speech. So these are the corrections, the suggestions, the comments, which were inserted for your benefit from the original draft that was presented to your representatives. So these are the changes, but when she's reading with the corrections made, with the comments made. So if you look at without delay, it has been deleted by the drafters, who we met just 3 weeks ago in the same hotel. So without delay is deleted. So when she's reading, she did not say without delay, but it's good for you to see the changes which your own representatives have made. And that's why it's beamed up there. It's tracked. So with a line across means it's deleted. When it's just in red, it's an insertion. It's an insertion, and she's reading it with the corrections for your benefit. Let me answer maybe the last speaker, and SG can also take it up. The domestication, honorable members, is done according to your constitutional and legislative jurisdiction. What is put here is to assist the drafter, and the drafter went through it. When they are now adopting or adapting, they can use various methods to incorporate into the legislation. And internationally, regionally, continentally, these are the 4 or 5 basic methods we use as legislative drafters to incorporate international agreements and model laws into our national legislation. The process will be done in accordance with your constitutional dispensations, meaning when this model law is finally adopted by the highest organ in SADC-PF, the SG will transmit this documentation in accordance with the normal procedures of transmitting to member states. And member states will thereafter distribute the model law in accordance with their constitutional dispensations. And obviously, the model law will end up on the Ministry of Justice or Parliamentary Affairs table, who will now transmit it to the parliamentary office to draft the necessary legislation. So at least that's the common process in most Commonwealth jurisdictions. The civil jurisdictions may have slightly a different process, but it will still end up with the state affairs, where they will actually now transmit in accordance with their jurisdictions. Maybe SG, you can add on to that.
Thank you very much. Maybe we should just take a few and then respond, but just to say, Honorable Magagula, that each jurisdiction, each domestic legislator may adopt the model law based on the relevant provisions that they find suitable. Therefore, in these circumstances, a model law is a model law, no more, but no less. So it would not be taken and be imposed on any country. It will be taken as a yardstick for anybody to look at. It's not a treaty. It does not have the same force like a treaty in the same manner. So the experience that has happened, we've developed other model laws before, and countries went to provisions that they find useful for them to adapt and use. So it is not taken wholesale, and it would be, each legislature will do so mindful of the specific country's realities and practical consideration. So that is what it is. I know you understand what I mean. It is not a treaty, it is a model. May I now usher in Seychelles? Should I add you to the?
No, I just wanted to comment.
Let me follow the list. Yes, sir.
This one, I'm just raising it so that we know where we're coming from and where we are going. It's on item 2.3. I don't want to labor, or I don't want the House to labor too much on this. A lot has been said, but I'm just raising the flag to the effect that we dealt with it under paragraph 1.2.11. And I was under the impression, yeah, there we are, that whatever we agree on that
I can hear you. So.
should take on board the discussions we had on 11, on 1.2.11. I thought there was still going to be some consultation as to how it might be modeled or be drafted. It's just Honorable Presenter, an observation so that we don't say one thing under one paragraph or under one caption that is different from where it's all started. It's continuity and uniformity. I thank you.
Thank you very much, Honorable. As you are aware, yesterday, I said I'm very much aware of what honorable members are discussing, and I shall take into account those as consequential amendments throughout the draft. So if you can see, as she was reading, I was actually highlighting the issues which have already been discussed and agreed upon. So in those highlights, when we come now to redrafting the documents, those are consequential matters that will be taken into account when we are redrafting. So I've already noted those, Honorable Member.
Okay, thank you very much. May I have space?
Finish up with the diplomat.
My understanding, Honorable members, is that this document has taken into account what was raised, and you will not see it there in simple terms. But for drafting purposes, because we're going to ask plenary and reconciling, the drafter needs to keep your amendments. That is why it is in yellow.
What does drafting means? Either to delete or to do away. I'm not diplomatic as the previous one, but we want it to do.
May I appeal for trust at this point? You'll have an opportunity to look at it again, honorable members. I'm giving you your word, my word that it is a drafting process for ease of the drafter to do her work. She has not ignored your contributions. Thank you. May I please have Seychelles at this point?
Thank you, Madam Chair. Under application and scope, 2.1, may we add, well, it should be the third sentence. May we add marital status as well? Proposition for consideration. Line 3, before, well, before birth or family status. It's okay? Got it?
Done, Madam
Okay.
Chair.
And the other thing, Madam Chair, I will still go back to number 3. What about for those ones that they've sort of having considerations for? What about countries with key populations that have been mentioned? How are we going to integrate these key populations, specific laws for them, if the document itself does not stipulate whether we should include them into the GBV, our national countries model law, especially for countries that are having these key populations. So how do we go about it if these such very important people are being extracted from the main document, the golden document? Thank you.
Thank you, honorable members. Let me just give facts at this point. There are countries in the region, in the SADC region, who have epidemics. It may be gender-based violence, it may be HIV, which are different and driven by different structural issues. We have countries where they call them having concentrated epidemics. Meaning, when you look at the broader population in that country, the majority of people who are affected are the groups that we are trying to delete right now. And this is where the concern is coming from. Then we have countries with a generalized epidemic, which means that those countries do find that the epidemic is higher among the general population. For us to eliminate, eradicate, prevent, you cannot have a generalized approach to dealing with those populations. It has to be specific and it has to be done in a manner that would ultimately serve that country. The question being asked currently is that, is this about only generalized countries with a generalized epidemic? What about us? And let me just remove myself from this debate that we're looking at now and say, we know normally at the forum when we debate issues, and that is why I kept saying, let us not look at our own country's realities and fabric of where we come from. Because you find that a lot of times we discuss issues that are in the mainland and we isolate island countries, issues of marine, issues of, even when you talk about peace and security, we forget that they also face a different challenge. And this is where the forum needs to recognize that it is not about other countries over others. It is about the togetherness of all the 16 countries. So the question that the honorable member is asking is that, what about South Africa? What about Seychelles? What about Mauritius? What about Madagascar? What about Zimbabwe? Because I know in the NSF they have it. Are we saying it does not matter for those countries to deal with the problems that they have in their countries, trying to eliminate the issue of gender-based violence? And I was quick to say, let us not subject this to a majority vote, because we are not at national parliaments. We are here to look at a gold standard. So I'm stuck, honorable members. Here are countries who are saying, what about us? What about regional integration? What about working as a community of SADC? Should we have said those countries that are going through X at a given time during political liberation, those who are safe should have said, no, we don't have those issues. So you go, we can't even listen to you. It has never been the spirit of the community. Let us look at the identity of SADC and look at those issues. Members should be able to recall that this is not going to destabilize or usurp the powers of the legislatures. This is not a treaty, it is a model. You pick and choose, but you allow everybody to be comfortable in this space where it is nobody's country. So I'm just putting it out there to appeal to the principles of how we've done it without also making each other uncomfortable on an issue like this. And just to basically reflect and say, is there anything that our ministers or our heads of states have signed to that contradicts this position? Is it the first time? Where did we get these from? Because we drew them from the same agreements that your countries acceded to. It is not copy and paste. We are saying let's accommodate each other. Let me not get into the gallery, but I just wanted to state the facts. I'm requested to open up for the thing is, it is not, okay.
Let's deal with this question.
You want to conclude, you want to answer the member, yes. not the substance of the populations. Can it be about, what about countries that feel strongly that this must be included? Let it not be about these populations, because now we are not, we don't want to spoil this.
Madam Chair, I think you didn't emphasize the fact that this is not a binding law.
Yes.
It's just a model law. It's just a guiding tool.
Yes.
And members can choose and pick what they want and what they don't want from the binding tool. But it's a regional guiding tool for all 16 SADC members countries. And no one country should feel excluded from the process of the model law. Otherwise, the issue of integration, cohesiveness, commonality
members, we'll resolve it, honorable members.
will be lost.
Honorable members, yes, we are resilient. Let us allow for cross.
Yeah, I think it's important that we maintain the spirit of SADC-PF and its meaning and the values that it stands for.
Thank you, honorable members. Honorable members, I know we'll get over this one.
Yes.
So let us just please, yes, allow for sharing. Remember, other countries are making an appeal, and therefore let us look at it in that context. Just to settle this one, Namibia wants to say something. I don't know if, yeah.
Is it on the same question or is it just?
I just want us to settle this issue. Then we move on to other contributions. Unless they're the same, I should go with my list. Should I go with the list? I'm looking at the, I should go with the list. Okay. I'll add Lesotho. I see Lesotho raise their hand as well. Okay, we just had Seychelles. Let me have Tanzania. No, let me go by the list.
Order, Tanzania is on the floor. Can we listen to Tanzania?
Yes, my contribution is on domestication of model law. If you look on the, as we are saying that the model law is not going to be imposed. It's up to each country to decide which to take and which not to take. But I just want to know, to get clarification on the use of some words in a legal point of view, the use of shall as opposed to may. If you look on subsection 1, on domestication of model law, it says member state shall. And subsection 2, member state shall. To my understanding, in a legal point of view, if you use the word shall, it means you have to do it. Then,
Before we clap, honorable members, this document is not a treaty. This document will not usurp your legislative powers at national level. We have model laws that we have developed. That can't, no, I know. I just want to, because it's not a legislation that we are looking at country level. We must remember that.
That's why what I'm saying is that if you look on subsection 3, it says may. So what I suggest is that as we keep on emphasizing that no one is going to be imposed or this will not be imposed, then let's use may instead of shall. Because shall, in a legal point of view, is that whether you like it or not, you have to do it. Then shall should be replaced by may.
Madam Chair, Honorable SG.
Thank you.
For clause 1,
Honorable
we
members.
can use order, otherwise we won't understand each other.
I don't like to say order of members.
Yeah.
Thank you.
Sometimes they are members of parliament, Honorable
Yes.
SG, they know the word order. So the first clause, we may use may, but for the second one, it has to be shall, because you have already signed off on these international agreements. You have ratified them. So you're obliged, you're obligated as member states to uphold the standards which have been enshrined in those treaties. So for the second one, there's nothing much we can do. But for the first one, we can use the term may instead of shall.
And 4,
If everyone,
subsection 4.
when we can, let me just deal with this one first, Honorable, so that we are assured. For this one, we may use may. If you don't want to domesticate it, you are not forced to domesticate it.
Yes.
Okay. Then for the second one, shall must stand. You have already obligated yourself.
Subsection 4.
Subsection 4, notwithstanding member states that have already in place national laws that prohibit shall review. Okay, may review. Yes, we can use may there. No problem.
Thank you, Honorable Zede, for that. Thank you so much. We will get there. We'll get there. So I'll add South Africa to the list. I've been instructed to follow the list. Then so now may I please have Zambia?
Thank you, Madam Chair. I think my first concern has just been addressed. But I just wish to comment. We may say this will depend on individual member states and so on, but look, we are heading to a point where if we look at the European Union law, it simply says where the European Union law crashes with a member state law, the member state bows to the European Union law. So I'm sure we are not here to waste our time spending a lot of money coming here. At the end of it, this law will be binding to all the member states, whether we see it or not, but that's why we are heading. To address my concern, it's subsection 4 on application and scope, there is a word repatriated. I thought that the word deported might be more appropriate.
Is it not in addition to repatriated, deported? What are the strengths, those who know? Committee clerks, assist us there. Is it, Madam Drafter?
I think repatriated covers it, Mr. Chair,
Yes.
Madam Chair. They are repatriated or extradited from one
Yes.
member to another member state.
That's what I thought.
Yeah, so it covers it.
If you,
I think deported is a bit too strong because deported has a lot of consequences attached there too. But repatriated can mean extradited, and it can mean moved from.
yeah, but when
Yeah.
we check it up from the English dictionary, you can only repatriate somebody to their original country. Whereas deportation covers whether native country or not. So let's check it up from the dictionary. We'll see which one is more appropriate, but I checked it out. That's what it means.
Thank you, Honorable. We'll look into that in terms of the legal context and enforceability, among others. Yes, I think we'll underline it. Okay. Let me have Malawi.
Thank you, Madam Chair, and good morning. Of course, my first concern has been was considered from my honorable member from Tanzania. Now, my observation is we are talking of our modern law as SADC, and we have included a lot of convention treaties from other bodies, but we want to have our own SADC model law. Why can't we come up with our own SADC model law? Because what we are seeing and what we are saying is the other treaties didn't give us the right treaties we wanted. That's why we are coming up with a SADC model law. Therefore, let us focus, make our model law to suit us. Thank you, Madam Chair.
Honourable members. How many countries have laws that are influenced by just the organic process? How many countries have laws that are not based on influence from whether declarations, conventions, or treaties, from the Rome Statute to wherever? How many countries? The only thing we can do is that we can then tailor to our own context. But this is the same heads of states, the same ministers who go and sign and agree to those with other parties. So I'm not sure how to address the issues of how we can just come up with our, I need assistance. I need assistance. Let me, yeah, I don't know how to put it. That's what I'm saying. I don't want to get into the gallery. Yes.
Madam Chair.
So may I request okay, let me allow the drafter, then I'll come to.
But I'll start with our constitutions, Honorable Chair. That our constitutions are actually, the majority of them, including Malawi, are based on the Universal Declaration of Human Rights. That's the basis of all our independence constitution as amended to date. So that's the starting place. GBV falls squarely within our constitutions. The non-discrimination clause falls under the majority of the international agreements which have been signed off and ratified by our member states. In our own jurisdictions, it doesn't matter the subject area. Where a subject area touches on an obligation of a member state internationally, signed and ratified. As draftspersons, we are obliged to domesticate in accordance with that international instruments. And I'm sure Malawi is actually a part of this group of states, because I was drafting legislation in Malawi dealing with the Public Procurement Act under COMESA, and we were obliged to use OECD guidelines for best procurement practices. And that's the law which is applying currently in Malawi today on public procurement. So I'm definitely sure, because even when I was working in Malawi on that, I was working with your draftspersons, and they were saying we are obliged to domesticate as part of the membership of COMESA. So when we sign international agreements, unless we've put a reservation, we are obliged in accordance with the instrument which states that member states shall take legislative, administrative, and other measures to ensure that this treaty is domesticated within their member states. Secondly, all member states sitting here today are part and parcel of the Vienna Convention on Treaties, which is very clear in its intent. It says, in summary, just briefly, that a member state cannot shy away from their international obligations by using their domestic law. Briefly, that's what the Vienna Convention says. And all member states are party to the Vienna Treaty. Thank you, Madam Chair.
Thank you very much. I'm going to try and avoid a dialogue, because I've understood that the honorable member was also trying to say, is there a way we can have an organic process for this one? But now, it should never be to the exclusion of what we've already agreed to as member states, because that has been taken on board. I see a follow-up from Malawi. Namibia is also saying they want to make a contribution on the same.
Thank you very much, Madam Chair. All what I wanted to understand was, are we supposed to abide to treaties which we see today? They're not very much relevant to us just because we agreed to them in the past, or we are supposed to change them to suit us today and in the future?
Madam Eva, kindly respond to that one. At the level of where we are now, are you asking for domestic?
Yes,
for in Malawi?
Yeah.
Here?
Just in general.
Yeah.
Okay, in general.
Madam Chair, the theory of puncta sunt servanda still applies. Treaties must be respected. What you sign off on must be respected. Yes, I'm getting what honorable member is saying from Malawi, that when we are adapting these so-called treaties that we are already obliged to, we must come up with country-specific or regional-specific laws. And that's what we have done in this model law. We have not ignored our international obligations, because obviously we cannot. We can't hide behind a regional model law and say we are disrespecting everything we have signed off on before, because really they're not suiting us today. Because the theory of or the concept for pacta sunt servanda still is retained. But we can adapt certain provisions to be regional specific and country specific. And if we go through the model law, you'll see that's what we've done. And that's why we state that we have restated the human rights obligations directly relating to GBV to suit our regional perspective. We have said as SADC-PF, we are setting a gold standard for our members to progressively achieve, all members. And that's what we aim at. the best standard is what we have here. And that's why the beauty of model laws is that you can pick and choose, honorable members, which provisions you want to domesticate and which you don't want to domesticate. It's not like treaty law, where you have not made a reservation as a country. And then you want to say, we are not domesticating this particular provision of the treaty. When you are doing your international reporting, you'll be questioned as to that particular article in the treaty. Why hasn't Seychelles domesticated this one? You have no reservation on it, because they'll take you back to the Vienna Convention. They'll take you back to that specific international agreement. So even when we are drafting model laws, honorables, and I've drafted quite a few of them, we cannot ignore the high-level international treaties that you have signed up on, because that is obligations of the state. And we'll be seemingly ignoring the obligations of states, and we'll be in problems. Thank you, Madam Chair.
Okay, I'm under siege. I need your protection, members, because I can't ignore my members next to me.
Not when I'm the.
Okay, let me allow Tanzania to conclude on this matter, and then Namibia, because they keep reminding me that DRC.
One is from Malawi.
Yes, from Malawi. So,
SG, I understand what the Malawi member of parliament said. And just if only all honorable members could go back to their positions in their August houses in the parliament. You are lawmakers. And I think most of us today is the day we are debating with Madam Drafter, because in the houses, we dialogue with the Attorney General after the drafting and everything. Why are we here with the drafter? Just because we want to see something done the way we want. It's nothing new. I appreciate and recognize the good job of the drafter, the learned sister, tested and seasoned lawyer, and the drafter. You know, you learn the law and then you go for the drafting. She's of high hierarchy. Not all lawyers can draft. I highly appreciate. My concern is when we ask questions, she should also read our levels and see what we are taking home. Fine, the document, seen as huge as it is the job she did. But we also need to put input, to add something or reject something. It's not a must that we take the whole thing as we are drinking tea or taking porridge. That's why we are dialoguing. So when all of you insist that it's a model, it's a model, yes. But then, even if you say it's not a must that we take it or not, but we are here as a region to see that we take things aboard together. And that is harmony. Yes. Others can also, or we can also keep quiet and say, okay, take or not. But that is not the spirit of lawmakers, members of parliament, honorable. That's why you should also go slowly with a tone which we can understand. I am with the Malawian member of parliament. With this changing word, are we also going to accept the things which are now, well, law doesn't change much, but if we see that there is something which we can change, we should not give the feedback just because the model is ready? That's my question.
Honorable members, thank you very much. We apologize if we are coming across as not taking the feedback on board. The idea was to clarify based on how we had the questions. The questions was based on the treaties and international law, and that was the response that was rendered. But the point has been taken. We are guided accordingly. What was trying to be done here was to differentiate, to indicate that even if model laws are done by a forum like ours, an intergovernmental organization, it does not constitute a treaty. That is why we're opening up and taking feedback from members. And I think what has been emphasized that it is not internationally binding, but we also know that a treaty and many others are open to ratification in our own countries. So I think the drafter and I are trying to say all the provisions that have become binding upon ratification for your countries are what is included and that which we cannot ignore. Because the assumption is that we are dealing with what you have already agreed to. So in the development of the model law, it contains those normative standards already that we believe that you have agreed to, that which guide each of our member states. That was simply what we're trying to come across. And if you recall yesterday, the drafter also indicated that often in international documents, you find that they're very vague. They're formulated in a very, they're vaguely formulated, so to speak, to allow countries to then go back and do what they feel specifically relates to them. So a model law has characteristics of both. That is why when Honorable Zede said, can we say may here? It was taken on board, without any argument. And therefore, that's why we keep emphasizing that the model law is not binding, simply to give comfort to the fact that these are going to be done. So where we got stuck, honorable members, is the fact that we want to accommodate both sides of the aisle. Where we have 5 countries saying, don't ignore us, we are here with you. We also want to address the issues. We are trying to find a middle ground so that we do not in any way make them feel that they're left out. And we need your contribution here because, yes, this is framed in the legal language of lawmakers rather than what we normally discuss in discourse. So we must bear with the drafter because sometimes our discourse needs to assist her in the framing and drafting. And in intervening, it is part of the effort of saying, how do I bring the regional discourse, match it with the international discourse and the desires of our members? So let us kindly be, apologize and just say, let us give each other, the give and take should just be based around that. And if we appear not to hear you, it is because we are trying to impart information and negotiate a neutral stand. I submit, Honorable Chair. Thank you very much. Namibia.
Yes, thank you very much, SG. I will try as much as possible to confine myself to the question, 2 questions. The issue of a draft model law and the issue of what do you do with the countries that, according to you, are appealing. Now, why do we need a model law? We need a model law as a guiding tool. We need a model law to give us harmony, to harmonize our laws. We need a model law in a SG's opening statement that will give us direction. Now, the question of direction, it is not just direction. It is the right direction. The direction in which our societies want to go, the direction that is morally correct in which to go. So our model law can never forget that aspect. Now, in this argument, the drafter and yourselves, Madam SGS, now the people that we are debating with, I see, you are giving two answers. It is not a model law. You don't have to follow it. You can adapt that which, according to you, should be adapted in your country. But at the same time, you are having this caveat that says, but your heads of states have acceded. Two things, one that says you are not forced, but the other one says you're actually forced. That's why this is here. That's how I understand and see it. To say that there's nothing wrong in this being here because your countries have already either acceded or are signatories to these instruments. So those two conflicting arguments I have quite a problem with. But that aside, how do you use the model law in the coming days? It's a lobbying instrument. Countries and parliaments will continuously be asked to conform to the model law, to the standards of SADC. Countries will continuously be reminded that you have not changed your law to accommodate this and this. That's a fact. Just like we are being reminded here that countries have signed to X and that treaty. We in Namibia have this thing of direct applicability in terms of Article 144 of international instruments. We are mindful of that. But that doesn't mean that we must accept a provision of a model law and then it goes to the country for us to maybe try and pull out of the treaty. Let me come back to the issue of what do we do with the countries that are appealing. Now, Madam SG, you have mentioned that maybe there's a specific problem, and I think you mentioned it, epidemic. You've termed it an epidemic in specific countries that are rooted in this problem, and hence the need for us to accommodate them. Now, I think we are really a close-knit community, a community that absolutely have no scuffles with one another as countries, or no major scuffles. And for that closeness, in fact, I want to call it love, we really should appreciate one another, and we actually love those countries that are praying for us to accommodate. But at the same time, it is also important to gauge the countries that we are talking about, the levels that they operated, and why these specific issues have now become epidemics in those countries, you term it. So
I think we're going to go.
No. What I'm saying is this. What I want to suggest is this. Maybe it is high time that within the community of SADC, instead of trying to get these issues into the whole community through means such as this, maybe it's about time that that issue be discussed in isolation as an issue. That if there's a need for the protection of specific communities in terms of whatever, that maybe SADC comes up with a law that caters for this, and perhaps a treaty that caters for this. And the communities and countries that want to accede to that can then go ahead and accede to that. As opposed to...
Honourable members, may we stick to the debate? Let us not cast, let us not get go that.
You asked the question, how do we accommodate these communities, these countries?
No.
Sorry?
What is segregation?
No, we are not segregating countries. We are segregating the issue.
We are being segregating because we are SADC countries. We are not those countries. We are within the SADC. So why segregation? Why segregate us? Because we are the one who appealed. Thank you.
Voices against each other.
Honourable members, let us stick to the debate. Let us stick to the issue at hand. The honourable member was asking two questions around, appearing. Honourable members, we are going to have tea break now. May we just, let's agree that the contradicting message that appears to come is simply because the SADC-PF is not a regional parliament. It has no powers over country. We have no supranational powers like the EU and other things. So no. If we read our proposal to summit made it very clear that they're not going to give the SADC Parliamentary Forum legislative powers. So the issue of shall and may, and that maybe this will be what we're eventually forced to do, shall not arise. I think we should have had maybe a briefing, because I think we have a lot of new members in this regard, and I see where there's a disjuncture. I see where there's a disjuncture, and yes, let me think about it. Let me think about it and see how we can integrate this. We assumed that your own parliaments had honorable members. It's time for tea. Let us wrap up. Let us wrap up, but I can see now that you're not hungry. Okay. Okay, I see that there's need for us. Order, honorable members. Order, honorable members.
It's okay.
Okay.
The room is.
Yes, it's lively.
I don't have room in peace.
Yes.
We're supposed to prefer.
Yes. No. It's not like I'm, no. All right, honorable members. The SADC Parliament has no legislative powers. But we are going there. Yes, we are going there with a clear proposal, which we articulated, and it's very clear where the powers lie. So even if we are going to transform, we shall not be changing laws like in East Africa, where what we come up with immediately changes what happens in countries. Remember, honorable members, even in your countries where you signed a treaty, it's not automatic except for a few. So let us really be rest assured. Lesotho has had their hand up, South Africa and DRC and Eswatini on this matter. I think then we must just take a health break, even if you're not hungry after this one.
Thank you very much, SG, Madam Chair. I think, yes, you have actually tapped into what I wanted us to maybe think about, because I thought we were now moving towards compromising our request of transforming into a regional parliament. Issues we feel that they are now binding upon us, but trust you me, we have